All right, let's start off with Alonsa Morris Taft and Michael Taft. See that Mr. Swenson is present, and I'll ask if Ms. Morris Taft is on the line.
Yeah.
Okay, welcome to you, Ms. Morris Taft. We're here today for a presentation from our hearing that was previously held related to the Mr. Taft's motion to vacate. I received a proposed order from Mr. Swenson, and Ms. Taft, just checking in with you, did you receive a copy of that proposed order that Mr. Swenson prepared?
Yeah.
Okay. Do you have any objections to that?
I don't agree with it. No, I don't agree with none of it. But I feel like I need an attorney, and I feel like I'm not given that right, which is I don't feel it's fair.
Okay. In looking over it, I recognize that you disagree with the court's decision. However, anything within the order that Mr. Swenson prepared that you feel is did not accurately capture what the court ordered.
I feel like they're all lies. They're trying to sit there and say that Michael, doesn't know any better and trying to make it seem like he's mentally ill when he's not.
Okay. All right. So I've reviewed that order. I'm fine with the form that's presented. So I've signed off on that order, and that'll be filed.
That's fine. Does that mean he still will have to pay the repayment?
Could you repeat that again, please?
I said that's fine about the software Benson. Does that mean he still has to pay the repayment of the $3,113?
Yeah, the $3,113 still remains part of the judgment. We just removed the doubling of that. So we just removed one of those. So it's just, yeah, so that still remains.
Okay, and will that be interest, the 12% interest too, since he's been having since it's been so long? Because on the decree it said he was supposed to pay that 30 days after it was signed by the judge. And since the spousal support just got removed, that just means that part got removed. However, since the reimbursement didn't get removed, that means he's in contempt for that one.
I'd have to take a look to see if the decree orders the 12% interest to accrue. I'm not sure off the top of my head. That's maybe something that you could take a look at the decree, and it would specify it there. Or if Mr. Swenson knows, he could answer that.
I believe it does have a 12% interest rate on the judgment.
Okay. All right. That'll conclude today's hearing. Thanks, everybody. Appreciate it.
Before we go, I filed the motion, and I also filed contempt for the repayment of the $3,113 only.
Right. I saw that you filed some other pleadings then with a docket in the future. So we'll address.
I didn't know if that was the right one or not.
Yeah, I'm not sure either. I just looked at it. I glanced at it briefly, knowing that it wasn't going to be on today's docket, so I didn't take a close look at it. So we'll let those documents speak for themselves and guide the next steps.
Okay. So what is the next? Do we have another court date regarding the proposed order, or?
No. I've signed off on the proposed order, so we're all done with that. And just the next, we'll take a look at that next.
I can't hear you. Sorry.
So we're all done for today's presentation order. So I've signed off on that order. The next court dates will be basically those that look like you've probably filed and set the docket notices to have heard.
Okay, awesome. Does this mean that he's still going to have the, do I need to serve the attorney still? Because since you signed off on this part, does he still need to be served as far as the reimbursement contempt? Because since you approved that he has to pay the reimbursement, that I'm just wondering, is that still?
So when an individual is represented by an attorney, there's you need to serve the attorney. There's certain instances when you need to serve the individual, but at this point, I think for the most part, serving Mr. Swenson will be out of it. But there are times where you actually need to serve the person. But Mr. Swenson can receive notice and service.
Okay, I did serve him, but I was wondering, since we have this signed off and everything, that now that you approved the reimbursement and you signed off on the vacated other stuff, is he still going to be his attorney for me, like for the contempt, like when the contempt coming up this court here? And that's what I'm curious to know.
An attorney remains on the case until they file a notice of withdrawal or they're removed from the case. So at this point, Mr. Swenson's notice of appearance is still active, and he's still attorney of record.
And I'll be appearing next week, Ms. Morris Taft.
For the motion or the contempt?
Both.
Okay, that's fine. As long as we clarified that you approved the reimbursement. He has to pay that, and I'm fine with the spouse support being vacated.
Starting ad litem, she's
Okay,
present.
very good.
And
All right,
Aaron
thank you.
Anderson, are you on
Ms.
the line
Morrison.
this morning?
Yeah, I'm here this morning.
All right, I see you. So we sent this over last week to give me an opportunity to read over the guardian ad litem report. I've done so, and I'll hear from the parties if you have any additional comments related to the recommendations of Ms. Height. Ms. Gilmore?
Ms. Height, do you have any further comments before I go forward?
No, thank you.
Okay, perfect. For the record, Megan Gilmore on behalf of the petitioner, Melanie Nelson. Since receiving the report, my client filed responsive materials as well as updated records from the child counselor. The report alludes the child wasn't going to counseling. However, that wasn't accurate as reflected within those records. When Aurora couldn't provide services because she changed roles, the child started going to another provider in that office. Given the short turnaround on the report, the recommendation was made without speaking to the child's providers, which I frankly understand. I mean, obviously this was happening within a roughly 30-day period. As reflected within the counseling records and communications from those providers, all of the children's providers are concerned with the recommendation to start in-person visitation without addressing the underlying breakdown in relationship and the child's anxieties. The providers recommend contact be reestablished in a therapeutic environment. This child was extremely forthright with the GAL regarding her anxieties. This child was threatening to run away or self-harm prior to bringing this action. The true question is what is in the best interest of the child at this point, and I believe the child's providers have better insight into how to progress forward given their history with the child. Outside of the provider's recommendations, I believe there's insufficient time and frankly evidence to automatically assume that this young child wasn't being forthright or honest regarding disclosing just her general personal knowledge of what was going on in the home as well as the inappropriate touching. Father's other children very clearly do not want to engage in the process. As reflected within the text messages attached to our reply declaration, the children are in fear of father's response and retaliation. So again, given the timeline and the lack of evidence, I just am concerned that we're just really relying on lack of disclosures by the other children as an automatic assumption that they simply just didn't occur. This child has no history of lying, and the last time she saw her father was 3 months ago. And at that last visitation, she disclosed inappropriate touching. My client supports the child's relationship with father, but is apprehensive about throwing the child into in-person visitation without doing the work of reunification. We believe that this will only further damage the relationship and delay the process even further. I think that we'll be back before the court because simply it just won't be going well. I hope that whatever we move forward is in the right direction. But given the history of this case, I just don't think that if you don't, again, resolve the underlying reasons, then we'll be back before the court. Since the last hearing, the parties have agreed to engage in reunification counseling, and I believe based on my communications with everyone that they filled out the necessary paperwork. When I spoke with Ms. Rosen directly, it sounded like she was going to be able to get providers started on this as soon as possible. My client has also started the process of having the child engage in individual counseling with Ms. Rosen directly based on the recommendation of the GAL, and she's more than willing to have the child go to her primary care physician, which she goes to on, a somewhat regular basis to consider medication. Given the fragile nature of the child's mental health, we are asking the court be cautious when entering this next visitation order. We ask that the court order visitation to commence with a reunification counselor as agreed between the parties, and visitation to progress based on the recommendations of that counselor.
Thank you. Ms. Gilmore, is Tess Howard, is she the therapist or the peer counselor?
The peer. Hannah is the one where I filed under seal that has the more formalized notes. And then I filed one from Aurora, which is the child's previous counselor who's mentioned in the report.
And the qualifications for a peer counselor are what?
I can look to, I would just simply be whatever is on her. Ms. Hyde, can you speak to that?
My understanding is that it's more based on
A lived experience?
yes, thank you. Yeah, the lived experience rather than any particular training. And my understanding at the time I wrote my report was that was the only counseling at that time that I was aware of with the peer counseling, which I frankly think it's great that she has somebody to talk to, but I believe as I think everyone else does, that she needs something a little more leveled up from that. And in fact, Aurora felt that as well.
And just to clarify, it's a kind of a bifurcated or two-part system. It's my understanding that Hannah is the overall supervisor with the true qualifications, and that's the notes under seal. And then Tess works with Hannah, who again is the peer counselor, to engage in more regular services with that supervision.
And then she's meeting, Isley's meeting with Hannah on a once a month basis and
I
Tess.
think it's twice a month with Hannah and then a weekly basis with Tess.
And is that anticipated that that would continue with the parent agreement between the parties as far as Ms. Rosen's involvement?
My understanding was the recommendation is that we just kind of cut off the core and just engage with Rosen, but we're happy to do whatever. I think that they have a established relationship, and that was a part of my concern in the declaration is we don't have anything with Miss Rosen yet, and so if we're not engaging something, the child needs some sort of provider. Just because it's hard to get into Miss Rosen's office, but like I said, based on my communications directly with Miss Rosen and my client's communications with her office, it does seem that we can get that established in pretty short order. But yeah, we can continue to engage with Tess Howard or solely Miss Rosen, whatever Miss Height's recommendation or the court.
And just one clarifying question. You used the term reunification counseling. Reunification counseling seems to have a kind of a porous borders as far as its meaning. Reunification counseling may be a parent who hasn't seen a child for 5 years, or a parent who hasn't seen a child or interacted with a child for 2 years. And now we're using reunification for a parent who hasn't seen a child for 3 months. Is that reunification counseling, or is that counseling with a focus on overcoming some issues that have occurred in the past and trying to work through those? So I just want to be careful on the terms we're using.
Absolutely. I think that it can be twofold, and I've had it either way, where people they're truly reintroducing. I think that it also can be reunification in the sense of a breakdown in relationship. I've had it where children refuse to go to visitation because of whatever is going on in the home, and it is still the intent of reunifying. So they do, and I just to clarify, Ms. Rosen wouldn't be providing the reunification counseling or whatever joint counseling it would be. Would have a service provider, so the child would be going with Ms. Rosen on individual, and then with a provider potentially on joint counseling, reunification counseling, however you want to term it.
Okay. All right. Thank you. Appreciate that. All right, Mr. Anderson.
I still very much stand by Ms. Height's report. I understand the reunification counseling portion of however we're titling it, with reunifying with Isley. It's been so long, but I also feel as a dad and how I've been in Isley's presence her entire life that I can handle her in any aspect. And this whole court process has been so abrupt, and I would feel unnecessary because I know in my home, in my care, or with Isley in my care and with my other 2 girls, there's never ever been a problem in my home. And even like I still talk to my other girls all the time, and I catch them up on all the proceedings and things that I'm going through right now. And even they still are just kind of like rolling their eyes, like, what the heck is going on? And I think that's one of the factors that's kind of at stake, is that there's so much verbiage being thrown around versus what's actually the fact. And, when I talk to my other girls, they even tell me, like, Dad, we've never seen anything here, and Isley has been fine, or Isley has been this, or Isley has never acted like she's in fear. Or they speak for themselves, like, well, no, we don't feel that way, Dad. You haven't, like, we don't know what they're talking about with how I'll react. That's never been shown. Like, what does that actually even mean? And that was when I brought up in our first hearing to you, Judge, that like the whole coaching element, like, it's all so abrupt and obscure, the whole thing. And I think that's the biggest issue for me right now, is where is this all coming from? Because my and Isley's relationship has been nothing but great all up until the one day I get served a restraining order. And it's been a major loss, because all of a sudden it's just like she's dead. I have no communication with her. I had no warning signs that this was going to happen. And I've already had extreme loss in my life, and I base a lot of my parenting and the way I treat people based off of the loss, especially like what's in the paperwork, the suicide of my dad. That's been a huge part of how I basically live my life, how I parent, with not having my own dad around and having to endure the hardship that specifically a suicide has brought on. And then all of a sudden, again, like, this is one more loss for me that just all of a sudden just happened. And it's hard to kind of navigate every day, because it doesn't make any sense to me based off of what I know and how Isley's been. And I kind of feel like that there's a stalling element, because I know Isley's going to be stressed out, because I know in Isley's heart, she knows what the truth is, because I've never, ever inappropriately touched anybody. And so if there needs to be somebody in the presence of when I reunify with her, that's fine. I also know how to deal with my kids when they're stressed out. We had my niece got killed in a car crash one day, but she lived with my other girls, and I had to adapt to that one day with having my girls in trauma, and I handled it just fine. And I feel that I can handle a stressed out Isley as well. And if I need to do that with a counselor, that's fine. If I need to do that with Anne specifically, that's fine. I just don't want to push this out any longer. And however I can do that, I would really appreciate it.
Thank you, Mr. Anderson. Ms. Height, any comments?
Just a couple of quick things, Your Honor. Thank you. First of all, I'd like Your Honor to know that both of these parents have been cooperative, responsive, helpful in every way with me. I truly enjoyed visiting and meeting both of them. And as this was a very short turnaround, I look forward to having more contact as we continue into this process. It's very obvious that both parents care deeply for Isley. Melanie wrote and spoke to me both that she wants Isley to have contact with her dad, but obviously she wants that contact to be safe. He has just spoken and he wants contact with her and feels that it is safe. I do stand by my report as far as what the older two girls and their mother said to me. I talked with each of them separately and independently, and there was definitely a thread through that was, I believe, uncoached, but very straightforward in what they were saying to me. I don't know what the underlying reasons are. I think everybody's concerned about that, but I do not believe that Isley is in danger from her father. And if she could have some kind of contact with him, I think that might help some of that anxiety to go down. I don't know what the next correct step forward is, but as I recommended, some amount of time in a fairly public space seems like it could be done in a way that would be less stressful for her than perhaps going for a weekend at his home. So I think we're all kind of at a loss to know why this is going on and what's the next best step. But I do stand by my report, Your Honor. Thank you.
Thank you. We'll give Ms. Gilmore just a few moments of reply.
And just briefly, I am somewhat concerned by the statement that we're generally blindsided by the fact that we're here. This child has been engaging in services for many years. We filed some of those records. There's indication that father was aware that this was happening. So, and we have text message evidence that's submitted within our materials that shows that while the child's at father's home, she's having those mental breakdowns and communications with mom. And my client is attempting to engage in those visitations and to, do breathing exercises and things like that to facilitate it. But at this point, we were at a point of no return, as my client simply just couldn't get the child to go to visitation, and with the crux of this disclosure of inappropriate behavior by father. So we are asking the court be cautious. We ask the court to start in a therapeutic environment or some sort of, not necessarily supervised environment, because I understand the safety concerns, but some sort of either with a provider or some sort at the visitation, even the peer counselor, to help facilitate that visitation.
All right, thank you. I appreciate everybody's input. Obviously, the humans are complex, and we're difficult to understand. Motivations, sometimes there's environmental factors, there's biological factors, there's other interpersonal factors, and they combine in strange and different ways. And so it's difficult at best to understand why we behave the way we do at times. What I do know and what I've heard from the parties is that both Ms. Anderson and Mr. Anderson are good parents, and that are deeply concerned about their girl, and they're taking the best steps that they can and taking the steps they feel will be in the best interest of their child. So what I think is important to recognize here is that this first started out with some reports of inappropriate touching and physical abuse. There were unfounded findings by both CPS, Child Protective Services, and also the CJAC, Children Justice Something Center, which is a forensic interview group. They both made those unfounded findings. I think it's interesting to note, not throwing any shade towards Isley's way, but when she tells me that every visit for the past 5 years that she's been pushed, kicked, slammed, or slapped in the face is not credible. And when her stepsisters say that that's never happened, and I recognize that stepsisters and their mother, there may be some extra pressures involved. The children certainly don't want to disappoint. They don't want to spread dispersions over a parent. And yet at the same time, I think that their mother is a mandatory reporter, and that adds an extra pressure that might overcome some of those other concerns of fear of retaliation or what have you. And then also based on Ms. Height's comments, just the demeanor in which those comments were shared. Tells me that that's likely not the case, that those things happened. So I think also that the issues of anxiety that ties into my initial comments about the very complex nature of human beings. There's can be a lot of reasons why people suffer through anxiety, and they may manifest themselves through completely different reasons or avenues. So I think the Ms. Height's recommendations for a physical through a licensed professional, Dr. Smenk was mentioned as one, and that discussion is to also include anti-anxiety medications and other therapies and modalities that may assist Isley. That's the main concern, to help her to feel well. It sounds like the parties have agreed to engage Isley with Ms. Rosen and her associates, and also to have some form of Mr. Anderson being involved in that process also. I'm not exactly sure when that's going to happen. Sounds like the parties have agreed on that, and that if that hasn't happened already, I'm assuming that a date has been set for those therapies or counseling sessions. As far as visitation, a cautious approach has been really engaged in this ever since these issues arose. And so there's, I think, Ms. Height's recommendation of a cautious approach of 4 hours per week with an exchange at the Kelso McDonald's is fine, and that can start this weekend, and then the counseling will be supportive of that. It may not go terribly smooth the first couple of visits, or it may, I don't know, and yet at the same time, I'm reminded of children that suffer through a lot of issues. Their parents are deployed, they're gone for a long absence, and then they're reunited and they work through the issues. So that's the hope here, is that she can work through those issues and the family can continue to be supportive and loving towards her, that get her on a good foundation. So that's the court's order. So I'm basically adopting the recommendations of Ms. Height with the nuance that the parties have agreed to, that counseling through counseling associates. So any questions or clarifications, Ms. Gilmore?
I know we talked about it. Are we going forward with Ms. Rosen only for individual? Ms. Height, can you give some sort of input on that? Just so I have direction for my client.
I think that it probably would be in Isley's best interest to consolidate that. I don't know what her relationship is with Tess, if that would feel like a loss to her. I guess I don't want her to feel like she's under a microscope all the time and has all these things wrong with her and needs continuous counseling several times a week. So I feel like having Ms. Rosen on board would probably be the best starting place for her and give her maybe the most traction. I'm not opposed to her seeing Tess at all, but I guess I don't want her to feel like she has so much wrong with her that she's constantly in counseling. She's just a sweet, vulnerable girl.
I'll talk to Ms. Rosen and see what her recommendation is, and maybe continue with core until we can get an appointment with Ms. Rosen. And then presentation.
Could I ask one more quick question?
Yeah.
Before we go there? Your Honor, in my recommendations, I asked for an itinerary so that if it's appropriate, I could stop in and visit with Isley and her dad a time or two. Is that part of your recommendation as well, or your order as well today?
Any concerns with that, Mr. Anderson?
No, not at all. I think that actually.
Yeah, I think that's fine. Yeah, so I'll adopt that also.
Thank you for that clarification, Your Honor. I appreciate it.
Do the parties feel that there needs to be some timeframes as far as the 4 hour visit? Does it, do I need to just set a baseline of noon to 4 unless the parties agree differently?
Yeah, I've been able to work with Mr. Anderson pretty well, so I don't have any concerns and I don't have my client's work schedule. Why don't we potentially discuss it this week and then set a presentation and then the court can decide if we can't?
Mr. Anderson, do you feel comfortable with that or no?
Yeah, that's fine. My schedule's pretty fluid.
Okay. If the parties feel comfortable with that, Ms. Gilmore could get that proposed order out to the parties, and you could all take a look at it, and I could take a look at it, and we could be here on the 14th of November to sign off on that. Does that work for everybody?
Yes, Your Honor. Thank you.
Mr. Anderson, I'll try to get you that order no later than Thursday.
Thank you.
All right, so we will see everybody on
Here we have,
November
Ms.
14th.
Dow.
Dow.
For
She
the presentation
represents
of today's hearing.
Ms. Jennifer Harris, and Ms. Dow is present, and I'll double check to see if Mr. Anthony Harris is present. Mr. Harris, are you here?
Yes, Your Honor, I am. Good morning.
Okay, good morning, and good morning to Ms. Dow. So we are here today on a motion brought by Mr. Harris related to the parenting plan. And so we'll hear from Mr. Harris first and then hear from Ms. Dow. Mr. Harris.
Okay, Your Honor, this is for the parenting plan or the contempt?
Contempt is my understanding. This is your motion for the contempt for your allegations are that there were missed visits on the 26th and 30th of September, related also to the Starlink modem and berating.
Okay, thank you, Your Honor. I've prepared my argument to be read to the court to stay timely and organized, and I asked for accommodation and patience. I estimate this will take about 6 minutes.
That's fine. Go ahead.
Okay. I filed a motion for contempt on October 3rd, 2023 for 2 reasons after you made an order for visitation in the hearing on September 12th. 1, the respondent missed visitations without any notification or agreement on Tuesday, September 26th and Saturday the 30th. The respondent conducted abusive use of conflict at my residence with my mother-in-law and my son and removed our internet utility without notice from the home, disabling the services on the 29th of September, causing our family to incur an unaffordable emergency loan to get new equipment and services, disrupting my children from home education access and telecommunications due to the remote location and need for specific Starlink utilities. The respondent emailed and texted, as well as followed up by her counsel on October 9th. A vague copy of her work schedule showing her unavailable for 50% of her visitation as ordered, and while falsely claiming to me that she communicated her work schedule and inability to continue visits as ordered in person on September 23rd, 2023. To this date, she has never asked to make up or alter temporarily any visits. She's not motioned the court for any modifications, nor has she changed her work schedule to fulfill the order of visitation. I must add that the respondent has missed visitations also on October 10th, 14th, 24th, and 28th. I responded timely to the email received on October 9th, a full denial with this alleged conversation ever taking place, that it needs to be moved before the court, and that it was never put in writing until the full contempt was filed and her schedule wouldn't conform to order. At the time of the response, I was still without Starlink services. Considering the new circumstances on October 11th, I received an email from opposing counsel and responded regarding Starlink equipment return orders by the court. I acknowledged her observations that I had internet while in the hearing on October 10th. I received my equipment far earlier than anticipated and pled before the court a 6-week wait time and had operating it on that day. I made a good faith compromise offer regarding the equipment costs incurred by her actions in response to their emailed request to keep the equipment anyway. I offered to settle as satisfied the contempt portion regarding Starlink motion before the court through waivered spousal support payments equal to the cost as ordered per month to equal the loan amount satisfying the damage. Considering temporary spousal support orders, I knew this was reasonable benefit for both constrained parties, settling the contempt portion of the Starlink equipment, as now I have an unnecessary loan payment as well as spousal that I cannot simultaneously afford. They denied this reasonably good faith offer, asked the court to order recovery of costs purchasing new equipment to pay off the loan taken and return the used equipment back to the respondent for her use, as I cannot return the newly ordered equipment. Opposing counsel will likely argue justification for the missed visitations, and this was notified and acknowledged by me that it was communicated to me on September 23rd that there would be a considerable alteration to the court-ordered visitation schedule due to work scheduling, and that I agreed to this biweekly change. This is not the case, and I would like to remind the court that the respondent has argued for full custody and that she can maintain this with her job at home. She has previously asked the court to pause on any parenting plan orders while she gets her life together, as well as requested a stay on any support orders against her, and this court ruled anyway. The court recognized the kids' lives just don't pause. The respondent has argued justification to remove the Starlink equipment because the debit card was shut off and she was concerned to be charged. I have not deliberately canceled or avoided making any payments to Starlink, or did I ask or risk any irreparable harm in contacting the bank, which they labeled the card as lost or stolen. The respondent argues a version that I deliberately shut off the card, and this was not the case. I did not consent or make any acknowledged agreement to reduce the visitation schedule that Jennifer has chosen to get counsel to fight for. I continue to oppose any delays in waiting for her to develop into a co-parenting role, while she gallivants using my daughter to develop her relationship despite care and safety concerns of the court record. This is how she chooses to be a part of our children's lives rather than focus individual and emotional attention during her very limited visitations and involvement of 16 hours a month, although ordered for 32. I serve the public as a paratransit driver. As a working custodial parent, my income is very limited. I live in a remote area that multiplies all aspects of my everyday transportation and repairs to my 2003 Yukon with over 200,000 miles, with no means to replace, although fully dependent upon. It costs literally every free moment and dollar I have available to carry out the needs of the children and home with no assistance from their mother. My estranged wife hasn't brought a dollar into our home in the entirety of the marriage, and for the past 12 months hasn't brought a single dollar of benefit to our children's lives.
Your Honor, objection relevance.
Yeah, let me ask you, Mr. Harris, how does that relate to the allegations of the missed visits, the modem, and the abusive use of conflict?
I'm sorry, Your Honor, I did.
Yeah, I think I'll sustain the objection, that portion of it. So if you can move to the next portion that doesn't deal with that portion you're just addressing.
Okay. I respectfully ask the court to grant my requests and contempt motion and combine the motion for temporary orders to limit visitations to being professionally supervised and documented
Your Honor,
1 day a
objection,
week.
that's not before the court.
I'll allow him to finish that, and I recognize that it's not before the court. So go ahead, Mr. Harris.
Anyway, I respectfully ask the court to combine the motion and have supervised and documented 1 day a week on Saturdays for 4 hours for 3 months. Ask the court order the respondent to provide monthly notes to me and for the court noted review. This will aid in determining the function and wellness of the parent-child relationship while determining the need for family counseling and establishing the safety and a structure way for the situation she has placed my daughter in with a man named Mr. McFarland. I'll just leave it at that. As reported in my recent filings for temporary orders on October 21st, my daughter informed me that, and my son, upon her return, that she was upset that her surprise from her mother was getting to visit with Mr. McFarland in an event for the Navy cadets. The same program he was my commanding officer.
Your Honor,
for my son.
objection relevance.
Yeah, Mr. Harris, as far as that, the allegations are that there were missed visits to the end of September. I know that there's allegations that there's been additional ones, the Starlink modem and the berating. And that seems to, talking about Mr. McFarland, seems to go beyond the scope of your filed motion. So I'll sustain that objection.
I apologize, Your Honor. I'll just refer the court to my concern and my pleadings as I navigate self-help resources and try my best to protect and provide the best I can for the children. Thank you for your time, Your Honor. I have nothing further.
All right. Thank you, Mr. Harris. Ms. Dow?
Your Honor, focusing on the motion for contempt, Mr. Harris's allegations of violation of the parenting plan by Ms. Harris for not exercising her visitation on September 26th and September 30th. She was at work On September 23rd, when she picked up their daughter, she told Mr. Harris that she would be working on the 26th and the 30th, and that she wouldn't be able to pick up the child. She's not in control of her work schedule. This is the first job she's had for many years. Unfortunately, the schedule gets in the way of her exercising all of the limited time that she was granted by the court's temporary order from the September 12th hearing. She hasn't yet moved to amend that order because she's been trying to work, get her living situation stabilized, trying to budget her legal expenses when we have to keep responding to actions by Mr. Harris. Contempt requires the finding of bad faith. She's not acting in bad faith when she has the conflict between the parenting plan and her work schedule, and she doesn't have the resources yet to amend that parenting time. There's not even a parenting plan in place. It was a temporary family law order with a schedule. As to the Starlink equipment, there is some question as to whether or not the court can actually find her in contempt when there was no written order entered at the time that she picked up the equipment. The line of cases addressing this issue allows contempt based on oral orders, but in each case, it's based on actual knowledge of the order. At the hearing on September 12th, the court made an oral order allocating vehicles, telling the parties that they were not to change insurance, transfer, or sell property. There was no mention of not taking property that belongs to and was used by the community. Mr. Harris presented me with a proposed temporary family law order from that September 12th hearing on October 9th, the day before the presentation hearing, which had to be redrafted because it was structured incorrectly, as well as leaving off the provision for Mr. Harris to request a drug test if he chose. We discussed that order with Ms. Harris. She was understandably more focused on time with her children. All she was thinking, as she says in her declaration about the Starlink equipment, was that she needed internet for her laptop. It's not something she can do on her phone, the kinds of things that she needs a laptop for. She has no permanent address. She's staying with her brother at this point, but she still doesn't have a permanent address. Mr. Harris has a permanent address. He could get another service, which he did. Mr. Harris's allegations about the cost of the new equipment are probably true. He probably did have to take out a loan to get new equipment. I don't have any information about that. What I do know is that he would have been able to return the new equipment if he had come picked up the Starlink equipment when he was asked to. We informed him on October 13th that it was here. He doesn't want Ms. Harris coming to the home, so she delivered it here. We immediately informed him that it was here. He didn't come get it until November 1st. As to Mr. Harris's allegations about my client's behavior when she came to pick up the equipment, his own statements are complete hearsay since he wasn't present. He wasn't even on the property. Her mother's statements that my client behaved in a, I'll quote, aggressive manner are so vague as to qualify as intentionally prejudicial without being probative in any meaningful way. Ms. Moore was yelling at my client, who did not reply. She didn't want to get into a fight with her mother. She didn't want anybody saying she got into a fight with anyone. She picked up the equipment and she left. We are asking the court to dismiss this motion. My client did not act in bad faith at any point here. She can't exercise all her parenting time at the moment. Hopefully she'll get there. As far as the equipment is concerned, as she said in her declaration, and as we've said here, she was not fully aware at the time that she couldn't pick up and use equipment that belonged to the community that she was accustomed to using. So we're asking the court to dismiss this motion and to disregard a good many of the irrelevant comments that Mr. Harris has made.
All right, thank you, Ms. Dell. Okay, Mr. Harris brings a motion for contempt based on the court's oral ruling from September 12th. At that time, the court made a ruling related to who remains in the home and who would need to leave, and Mr. Harris would stay in the home. I set a visitation schedule from Saturdays, noon to 6 p.m. for the mother, and a midweek visit on Tuesdays from 5 to 7. There's made mention that there'd be joint decision-making on various issues such as educational and medical. I made decisions related to use of vehicles. And what's important is that often what happens in these motions for temporary orders, there is a lot of granular detail that often isn't directly addressed in the oral comments by the parties nor by the court. So I went back and looked at the clerk's minutes to see if I had made mention of any, don't dispose of any property, don't take or exchange or sell it, or anything related to like don't change insurance. I did not make any, clerk's minutes don't reflect that I made any rulings related to that. And I don't recall making any comments related to that. And while there may have been some argument on that, I don't specifically recall that. And that's kind of the difficulty with oral rulings, is that oftentimes there'll be an oral ruling and then some of the smaller details that nobody really argued a lot about just become a part of the order when it's written up and presented. And the court usually finds many of those provisions acceptable and will sign off on those. However, in this situation, the issue related to the modem about not taking property or exchanging it or selling it or removing it was not directly addressed. So without it being directly addressed in either my oral ruling per the clerk's minutes in my memory, so I don't think there's a basis for me to make a finding of contempt. So related to the Starlink modem, I won't make a finding of contempt, and I'll deny that contempt motion related to the Starlink modem. Related to the missed visits, obviously, obviously parenting time, residential time with children is important and should be valued. And Mr. Harris, I get a sense that he had other plans because he assumed that mother would make those visits and spend time with her children. And that's got to be frustrating for him, and probably equally frustrating for the mother. She's out working and having a job and needing to earn income, and conflicts with her work schedule with the visit schedule. So there's competing explanations of what happened on the 23rd. Ms. Harris indicates that she gave notice, verbal notice, oral notice to Mr. Harris that she wouldn't be able to work on those dates because of her work schedule. Mr. Harris denies that happened. What I do know is that I think in the future that there needs to be some clear communication regarding residential visit time. If the mother is unable to exercise that residential time, then she needs to give 24 hours notice to Mr. Harris, and that has to be in writing. Whether it's email or text or what have you. So regarding those visits, I don't think there's a clear showing of contemptuous behavior, because we have those competing references related to what was or was not communicated regarding mother's availability for the visits. So I'm going to deny that the motion for contempt related to that. But I am making an amended order, kind of a proviso to the orders that were entered on November 3rd, that mother must communicate any inability to exercise residential time. And the hope is that she hopefully with time can get things squared away, because obviously the children need that time with their mother. So it related to the last issue on September 29th, where there's allegations of yelling, aggressive behavior and the like. While that's certainly unbecoming and inappropriate, again, the oral ruling that I gave on September 12th, I don't recall that, and I didn't see that specifically noted in the clerk's minutes. So I'm going to deny that also. Certainly, we want to encourage people to be on their best behavior, to be civil, to be kind. But here, I think there's just not a firm enough basis for me to make that finding. So I'll deny that portion of the motion for contempt. So what I'd like to do, excuse me, related to the communication requirement of the 24 hours, I think I'll just do a bench order to that, and then I'll file that, and I can send copies to the party so you have that. I'm going to take a moment and draft it right now so you all know what it says. So give me just one moment, if you would, please. Proposed order reads, it's hereby ordered father's motion for contempt, missed visits, Starlink modem, berating behavior is hereby denied. Mother shall communicate in writing to father at least 24 hours in advance of any scheduled residential time mother is unable to attend. Any concerns with that language, Mr. Harris?
No.
Okay, Ms. Dow.
Sorry, there's a little background noise. No, we're fine with that language, Your Honor.
All right, very good. I'll go ahead and sign this order. Since I've read it to the parties, I'm not going to send it. If you need a copy, you can check Odyssey.
Thank you, Your Honor.
All right, that'll conclude things for today. Any other items?
If you don't send it, Mr. Harris, if you don't receive it, please let me know and we'll send you a copy. Mr. Harris doesn't have access to Odyssey.
Oh, I'll Mr. Harris, do we have your email address or?
Yeah,
okay.
I believe you do, Your Honor.
Yeah, let me double check. I should have it here. I'll make sure and get a copy out to both parties via email today. I'll do that once we're done.
Right,
Thank you.
thank you, Your Honor.
008.
Right, thank you.
Ms. Winkles is present. She represents Jeremy
That's what I
Bamer. Ms.
have.
Gilmore is present. She represents Crystal Kelly. And I see that Mr. Bamer is on the line. Mr. Bamer, can you hear me okay?
Yes, sir.
All right, very good. And is Ms. Kelly on the line? Ms. Gilmore?
I believe listening via YouTube because she's actively at work.
All right, very good. All right, so this is Ms. Kelly's motion for modification of a parenting plan, child support, attorney fees, and the like, with some interesting issues. So we'll hear from Ms. Gilmore first as the moving party, and then Ms. Winkles.
Megan Gilmore on behalf of the respondent and moving party, namely Crystal Kelly. I'd first like to memorialize my objection regarding the numerous materials filed on Friday and Monday of this week. I did present that objection to the court via email. I do apologize. That's relatively informal, but I didn't have any ability to get anything filed. So we are asking the court does not consider that for the purpose of this motion today. Our original motion was filed in September. The court, if you do recall, set this over, I think, at least 3 weeks. So he had plenty of opportunity to respond. He filed under penalty of perjury a response on October 24th. And so those materials were, filed in violation of Local Court Rule 88. I'm also objecting to the consideration of the letter filed along with his responsive materials by Heather Hoke. We're just asking that that is not considered because it was not made under penalty of perjury and she doesn't have personal knowledge to what was going on in my clients.
Okay, well, let's go ahead and just address that, just those discrete issues. Ms. Winkles, do you have a position?
Yes, Your Honor. I came onto this case on October 16th. Prior to that, he was without counsel as his former counsel did withdraw at some point. That gave me a very limited amount of time in order to respond. In order to get the child's records, because really what we're talking about here is the best interest of the children or the child and how it impacts. Really, the best way we can do that is to have counseling records. Mom had some counseling records. Dad had no access. This is a child that's 13. We're on the child's timeline. If the child wants to give them, great. If the child doesn't want to give them, we wait. We waited till the child decided it was time to give them to the court. We've got them. They're with the court now. They're probably useful in determining whether or not this child's really been impacted. With regards to my client's supplemental declaration, there was new information presented in Mom's responsive pleadings. My client had no opportunity to respond to that. Additionally, my error, I did put that my client was on naltrexone. He obviously must have skimmed when he read it because he had typed it out first or handwritten it. And this is my fault. I had confused him with somebody else, a different client of mine. So he did want to clarify to the court, I'm not on this medication. That's a very small issue. His supplemental declaration is quite short. It just addresses a couple of new items that are new information that weren't in Mom's original. The medical records are the child's records. They're useful. They're necessary. Even though they're late, they are necessary. Mom had access to them already. So it's not prejudicial information that Mom is just seeing for the first time. This is Mom had them in her care and custody and cherry-picked which one she wanted. My client didn't have them. And again, we're on kids' time here because she's 13. So I'd ask the court to give whatever weight the court wants to give to them. But since we are looking at the child here, I'd ask that those records be used. My client's declaration is supplemental. It is small. It's small and just clarifies a couple of things that were new in the other one. So thank you.
Thanks.
Sorry, I'm not objecting to the medical records. I have no objection to that. I'm just, I'm objecting to the underlying declaration. It was 4 pages. My client, I don't believe, presented any new information within her reply materials. They were all responsive to the allegations and frankly, really pertaining to the allegation. This was a final parenting plan. So I am asking the court not consider that declaration.
Okay, thank you. I think the children's medical records are key, so I am considering those. As far as the second declaration that was filed by Mr. Bamer on November 3rd, I'm not considering that. Ms. Hoke's information, I'm not considering that either. That's not under penalty of perjury, so I'm not considering that. Okay, with that, we'll hear from
Yes, thank you. How far does the court want me to go into the procedural issue of the final order? Do you want me to move forward or do you want me to get into the meat of that?
I spent a lot of time with this case yesterday. I think a brief review would be helpful to just kind of bring it back to memory. So
Yeah, absolutely. I'm happy to do so. And again, Megan Gilmore on behalf of Crystal Kelly. This is before the court on my client's motion to modify, particularly the temporary parenting plan. First, the parenting plan entered in April of 2022 is clearly a temporary order. And I'm frankly frustrated that my client must spend fees defending this claim, given the clear reading of the order and intention of the parties that we've submitted within our reply materials. At the time my client was forced out of the community residence, petitioner with an attorney presented her a separation agreement. As detailed within her declaration, she signed the order without counsel and frankly what she believes under duress, as she had no funds to acquire her own housing and needed to have visitation with her daughter. However, no one, including my client or petitioner, believed that they were signing or entering final orders at that point. Even if we go beyond the extremely questionable nature of how this agreement was derived, the parties clearly again had no intention of making the parenting plan final, as this was not filed with the petition, but rather was filed in two separate filings of proposed parenting plan as well as a temporary order, which was memorialized with the court. Moreover, the order itself makes no reference to the fact that this is a final order. And at the time my client signed it, she was a pro se litigant. She had to rely on the face of the order and the communications between the parties. Beyond the fact that the face of the order makes no reference to the fact that it's final, there's no sort of subsequent orders that are required under statute, particularly findings of fact and other final orders, particularly relating and required with unmarried participants under RCW 26B020. You need to make what's required for the court to enter a final parenting plan pursuant to statute is making findings about, frankly, paternity in this case. These parties aren't married and that's required, even jurisdiction or child support. So this is further supported by the written evidence and the text messages between the parties. The parties were negotiating the terms and discussing going back and forth with petitioner's attorney on making said modifications. When the clerk's office provided notice of dismissal again, because there was no understanding this was finalized, petitioner's attorney filed a status report indicating that the parties were still negotiating the final orders. There's nothing to support petitioner's claim that the April 2022 parenting plan is final. We frankly believe he presents this allegation as a red herring to distract the court from the legitimate issues we believe are within his home. The court, again, clearly is what the information before the court is that this is a temporary parenting plan and nothing more. Furthermore, I present case law analysis that the court isn't bound by separation agreements and again is able to modify temporary orders upon a finding that the temporary parenting plan is no longer in the best interest of the child. So we do ask the court today make a finding this is a temporary order. Moving to the underlying merits of the motion, I already presented oral argument in support of our motion at the last hearing, so I'll make my arguments relatively brief and rely on the materials presented by my client. My client filed this motion as the child's mental health was severely declining in response to father's alcoholism and the conflict in his home that resulted in the child calling law enforcement. I'm frankly very concerned at the tone of father's response to the materials, as he's clearly isn't taking any accountability for his alcoholism and is willing to frankly make every excuse to avoid addressing the issue. The child's mental health records speak for themselves and truly show that this child is struggling during 50% of the time with her father. Following our hearing, father took it upon himself to inform this fragile 13-year-old child that my client presented the court, number one, with the mental health records and explained the information contained within those records. The child was threatening self-harm related to visitation with father. The child was absolutely devastated, and we believe that father presented this information to the child in an attempt to damage my client's relationship with the child. He then took it upon himself to change the child's mental health facility without any conversation with my client. We do acknowledge that the child's previous actual provider was going to another facility, or frankly, I don't know why she needed to no longer provide treatment, but my client was actively engaging in providing with another provider at the same facility. Father then again took it on himself to make an appointment with a different facility with no notice to my client. He not only changed the facility, but then threatened the child with a subpoena when she refused to sign the release of information. My client is concerned by this. She was able to access the records previously prior to bringing this motion because the child wasn't 13 years old. But my client does believe that the child mental health provider needs to be someone that the child can rely on. And I am frankly concerned that we now have those records suggesting that those threats were made good upon, and he did force the child to sign those releases. I do appreciate the fact that it's needed for the motion and it's hard to balance that, but we don't believe it involving the child in conflict is appropriate. At my direction, my client requested a hair follicle test of petitioner to establish a baseline of father's drinking. The hair follicle shows long-term use. Father's in such denial that he's now trying to make claims that this test isn't legitimate or accurate without any sort of evidence proving that. Father then thought it was appropriate to send said drug test directly to the child in support of his threat that she must go to visitation with him when she was apprehensive. Father presented a declaration or penalty penalty of perjury that he was taking a drug to help him with alcoholism. I'm confused how you state that that was made in error when it was signed by him under penalty of perjury weeks ago. Father similarly presents in his declaration that his last DUI was when he was 18 years old, but the records, the watch report very clearly show that the last conviction was from 2020. This motion was filed 6 weeks ago, and at this point we have no evaluation from Father. We have no proof that he started any sort of legitimate treatment, and we have a positive drug test for alcohol. Father asked the court to indicate that he's addressed his non-existent issue because he's done 2 online AA classes, which are frankly insufficient given the facts of this case. Beyond the alcoholism, I'm frankly shocked that number 1, Father admitted to telling this child to kill herself, and number 2, that he now under penalty of perjury tries to allege that's a joke. This is the same behavior that my client experienced during her long-term relationship with Father. Father becomes intoxicated on a daily basis. He hurts people verbally or physically, and then apologizes, claiming he'll stop drinking, only then to drink the next day or week. Father is in such denial that he admits in his own declaration that he doesn't need treatment. And unfortunately, I'm confident that it's not if, it's when Father will start drinking again to the detriment of this child. So we do ask the court to grant our motion and adopt our parenting plan. I do think it's necessary in this case to get a guardian ad litem. I ask the court, if our parenting plan is granted, to consider entering an order of child support. And I do ask the court to consider fees. I understand that a committed intimate relationship doesn't allow for fees, but again, my client was a pro se litigant for a vast majority of this litigation, and it should have been filed under 2 petitions, a petition for committed intimate and a petition for a parentage or parenting plan. And under a parenting plan analysis of RCW 2626B060, my client does have relief for attorney's fees, and we think that that's legitimate given the facts of this case. Thank you.
Thank you, Ms. Gilmore. All right, Ms. Winkles.
Yes, Your Honor, that's a lot to unpack. I'll start with the orders. So what we have here is we have a CR2A, and the reason we know that is because number 1, litigation had already started. This isn't your typical separation agreement. This is an agreement made contemplating litigation that's already ongoing. We can tell that these are final orders because number 1, they don't say anything about being temporary, but more important than that, they're all signed by a notary. They're all signed on the same day. They're signed back in March. We can clearly see the negotiations going on that Mom has entered with the court are on what is missing from this CR2A. It's not a complete CR2A. It's a CR2A on the distribution of assets, which nobody's arguing here. We all agree that that's done and dusted and done and has been settled. And what has also been settled is visitation. Child support has not been settled in this case. Neither is the final testimony been entered in the court. You can clearly see that they are still arguing about child support and about who's paying for what. And with regards to the parenting plan, what was entered was intended to be final. It is clearly confusing in the court record because it does say temporary. These parties, once the other attorney got out, you had essentially 2 people not really knowing what to do here and calling child support parenting plan. But the parenting plan was clearly meant to go with the other documents that were meant to be final. It would be strange. It would be a strange outcome if they signed 3 documents under penalty of perjury, if they signed 3 documents in front of a notary, and 2 of those were meant to be final, and 1 of them was not. And the one that was not never indicated on its face that it was not meant to be final, but the other 2 were meant to be final. That result doesn't make any sense. We believe that in this case, and there may be adequate cause, but we believe in this case, what we're dealing with here is a petition to change a parenting plan at this point because the CR2A, or to essentially vacate whatever. My client did file a response to that. The outcome of that would be roughly, we'd be in a very similar situation. However, we'd have to look at a change in circumstances. I won't argue that point unless Your Honor wants me to. I'll argue just the temporary plan at this point, or I'll argue just if Your Honor believes there's been a change in circumstances, or Your Honor believes that there's been a temporary order and this is the result, I'll argue what they're alleging. We have to go back and look at what child.
Could I just interrupt? Might I interpose a question to both counsel? If I were to make a finding that the CR2A was to be, at least in the minds of the parties, a final order, does there need to be a motion filed for adequate cause that there's been a change of circumstances for the court to make any changes to any parenting plans, or is it kind of subsumed within the pleadings that there is an implied motion for adequate cause and modification? So I'll hear from the parties.
I mean, yeah, there is an assumption that moving forward without a cause, if that is the court's ruling. Ms. Winkle filed a response to a non-petition. So I think, for the intention of the parties, I guess at this point, we're either arguing adequate cause or we're arguing a modification based on the best interest of the child under a temporary parenting plan.
Thank you. Ms. Winkles?
Yes, so procedurally, there's three ways that you can bring adequate cause to the court. One is obviously the petitioner moves, the other one is the respondent moves, or the court itself moves. And in this case, as much as I'd like to, say that we could delay by me saying, well, neither the petitioner nor the respondent have done so. The fact is that we're arguing it really. So the court would have the ability to say we're arguing adequate cause, and Ms. Gilmore needs to do a motion. Probably she could do that motion after the hearing at the same time, because Your Honor would essentially say that we were doing a motion for adequate cause just based on what the parties are doing. But there has to be a motion in the record for it to be procedurally correct if that's the way we're going forward. And there has to be an order and adequate cause. You cannot change a parenting plan for anything that's major, which is what's being requested, without that motion and that order being in the record.
Could I ask a follow-up question? Ms. Gilmore alluded to that there's three ways that adequate cause can be brought forward. One would be the petitioner or the respondent file for a motion, or the court could do that. Can the court make a sua sponte motion for adequate cause and make a finding of adequate cause? Ms. Winkles?
Yeah, so based on what the parties are doing, I can't remember the word for the life of me right now. If the parties have argued, it's you can go back and almost change the pleading from, I can't remember the word, it's driving me crazy. Based on what we're arguing, Your Honor has the ability to motion, to essentially say we are motioning, but we need the underlying pleading. Because I've essentially argued it as well, I've waived the ability to object to if Your Honor says we're doing a motion for adequate cause, I would essentially have waived that by arguing this out anyway, if that makes sense.
It does. Yeah, I appreciate both parties' input. I think maybe it may be best just to streamline the argument for the court to make its decision related to whether it's a final order or a temporary order. Here, at least in my view, the agreement. Well, there's arguments on both sides. The agreement, to me and to my mind, seemed to be a final order. And the reason I say that is that it was fairly comprehensive. The CR2A addressed a lot of issues, addressed the home, it addressed property, it addressed parenting plan, and it addressed assets and visitations. It did leave out child support. And then after that information was signed and then it was filed, basically it was left to sit for a year. So, if I put myself in the shoes of the parties as they're negotiating and working through this, both being at this point, at some point thereafter, they were not represented. There's a sense there that they let it lie because they thought they were done. So I think that's fairly significant. When the attorney for Mr. Bamer indicated that, hey, in response to the want of prosecution, hey, we're working on things, we're negotiating. That was a year after the documents had been signed. So that very well may have been child support, it may have been other issues, but at least in my estimation, there was the intent of the parties to have signed off on final orders through the manifestation of the CR2A and other documents that were filed. So related to adequate cause, I'll make a finding that there is adequate cause to modify the parenting plan. And that's based on certainly a change of circumstances. There's been some concerns related to the separation and how that's impacted the child and how alcohol may play a role within that separation and how that impacts the child. So I'll make that finding of adequate cause.
Okay. And then I would suggest, Your Honor, that Ms. Gilmore prepare that motion just so that the court record follows.
Okay. Ms. Gilmore, are you comfortable with that?
Sorry, just for the cleanest version of the record, I will likely file a petition and motion for adequate cause, just to be the record, to be clear.
Okay. All right. Thank you. Appreciate that collaboration and help. So, Ms. Winkles, do you want to pick up from that point and continue, and then we'll get some time?
Yeah, absolutely. So we have to really look at what the child was suffering from before the parenting plan was signed. If you look at the mental health records and the records of the child, we see a child that already has some underlying mental health conditions. She's already anxious. She suffers from some essentially physiological changes from this anxiety. Doctors, if you read into what the doctors were saying during her visits, They were concerned that she was either hypochondriac or that she was having psychosomatic physical changes due to this anxiety or attention seeking. You can see that because she comes in for heart problems, stomach problems, head problems, hyperventilation, things of that nature. And the doctor notes, she's tender, she's complaining of pain, but then she jumps off the table. She's complaining of being breathless and not being able to breathe, but then she's talking normally. So the doctors are concerned anyway that the child is essentially attention seeking. And this makes sense. This is a child that was essentially, and I won't use the word spoiled, but maybe all the attention was focused on this child during this relationship. And then suddenly we have these parties separating. Child is no longer the number one. These parties are arguing. So they start, the attention becomes each other, really. And then the attention becomes this new partner. Child is receiving less attention. So child is attempting to create conflict in order to have the attention back on her. And we see that through a number of things. Number one, every time she's with a parent, she has conflict. You can see that in the mental health records. When she's with mom, she has conflict with mom. She's talking to the counselor about all these issues she's having with mother. Only when mother goes to the counseling appointment themselves does suddenly the child, is great with mom, is working out with mom because mom is giving child attention. You see the same thing with dad. Dad is an alcoholic. Dad has all these issues. She doesn't want to go to dad's house until dad suddenly is essentially babying the child and giving the child as much attention, concern, child has cramps, child goes to doctor. Child, hurts or injures her thumb, child goes to the doctor. All of that, suddenly child is now back in dad's court. And so really catering to the child is probably not the best way forward. And both of them need to probably have the entire group needs to have some family counseling, that's for sure, in order to get on the same page about how to deal with a child that needs attention and how to deal with a child, children in between, how to deal with a child when there's conflict and all of that. But really the crux of this is dad an alcoholic? Dad never said he had one DUI when he was young. He did have one when he was 19. He also mentioned that he had one in 2019. These are two different DUIs, obviously. They're 30 years apart or whatever. Dad made a mistake in 2019. Dad does have some poor coping strategies when things get tough. That might be drinking. Dad doesn't drink on a daily basis. Dad doesn't drink to get drunk. Dad goes long stretches, years without drinking. Dad has some poor stress related issues and dad may have a drink when he gets stressed out. However, it doesn't even matter because dad has already entered treatment purely. And again, this is possibly catering to the child, but maybe the child needs this right now. Dad has entered treatment, not just 2 sessions of AA, but dad has gone to Ideal Options and gone to Cowlitz County Tribal Treatment. And the SUDS is included at CP34. So I'm not really sure this evaluation was included at should have been included at the top of CP34, right in front of the child counseling records. Dad went through and dad was very honest. And you can see everything about dad's drinking in there, including the DUI and everything like that. They didn't feel dad needed treatment. Dad is going to continue treatment though. And the reason he's going to do that is he wants to show the child that he is, he's willing to work on things, whatever she feels that there's a problem, he needs to work on. And so that's what he's trying to show her.
Can I ask you what his treatment is? Because they may said, no significant problem, no treatment recommended. So what is the treatment plan?
So the treatment plan, dad is actually he is doing NA. So he's doing NA, I believe, once or twice a week. On top of AA. I always get the two wrong. He's doing AA once or twice a week. And he's also going to Cowlitz Tribal Treatment for counseling. For, I guess it's non-medicated treatment. It's counseling, peer therapy, things of that nature.
Once a week, twice a week, 2 hours shot.
And I don't actually know this because the SUDS came in so late. If I can just have my client, if Your Honor doesn't mind.
I would love to know that.
Mr. Bamer, how much are you going to that therapy at Cowlitz Tribal Treatment?
Twice a month. Twice a month, every other week.
Is it a group setting, individual setting?
Me and my fiance.
And then you meet with the counselor?
Yep.
Okay, thank you. Ms. Winkles?
Yeah, and then on top of that, he's doing AA as well. and he's also doing it with his girlfriend. And that is purely to have this a sober household. So that's the whole idea, is treatment doesn't hurt anyone. But my client states that a lot of this is just blown up. And you can see this in a fashion in what the child tells her counselor and what the child tells the doctor and what the child tells everybody. First, she says, Dad doesn't drink around me. There's 2 instances where Dad had a beer and upset her, just the one beer. So child is hyper focused on this issue. Dad has a beer, child gets really upset. Dad then stops drinking completely in the house. Child mentions that in her record. She said, Dad doesn't drink at the house around me. And he doesn't drink there because he's not an alcoholic. He doesn't need alcohol to sustain himself. He doesn't have a dependence on it. He doesn't drink when she's there. She's still hyper focused on this issue. You also note that child says, nobody believes he's an alcoholic. Mom and grandma, something about mom and grandma are denying it and they don't believe it. And that's because mom didn't believe it until suddenly she needed something to grasp on. We also noticed that mom is really the one pushing this forward. So when they're at the doctor, it's not the child who's disclosing this to the doctor that she's upset and she's sick to her stomach because of Dad's drinking. It's mom. Mom says to the doctor, I had to pick her up because Dad was drunk. That's clearly mom inserting herself. And we see that time and time again here. This is not a change in the child's mental health. The self-harm, possibly. But really, this is prior to the relationship. When mom moved out with her new boyfriend, James Wagner, she made daughter hide this issue from Dad. That caused the start of all of this. And child was really upset to have to hide this relationship, to move in with this new man, to be in a house with a third-party male that she doesn't know. That was a lot on a 12-year-old little girl. She started having stomach issues, missing a lot of school and the like. This anxiety and this hyper focus on Dad is new. And that happened after Dad said to his child, which he possibly shouldn't have. And again, some parenting classes are definitely in order here. He told his daughter that he was going to marry his new girlfriend. Dad is a middle-aged man, doesn't understand that might affect a 12 or 13-year-old little girl. Maybe and not sexist in any way here, but quite possibly you could tell a male child that and it would be absolutely nothing. But to tell a little girl that was probably Dad's not a shining moment. And in any event, child became hyper-focused on any flaw she could find with Dad. My client's not sharing things with child. Child seems to know things that child shouldn't know, which is actually just making my client's life more difficult. The reason he showed her the UAs that he took is because child demanded to see the UA or refused to come to his house. So my client did it and showed her the same reason he's going to treatment. He wants to show her that he's willing to make this extra effort, that he's willing to work with her, and he wants her to feel safe in his house. Now, concerning the allegations of domestic violence, we have the woman who is supposedly the victim here saying this never happened. We have a chaotic scene where the children are all showering. It's flooding the floor because these are little girls. They're flooding the floor. Somebody runs out and tells Dad the pipes broke. Dad runs in, kind of moves everybody out of the way. And then they start moving furniture. And I'm sure everybody was screaming. And I'm sure, when things like that happen, I'm sure people were, maybe even bickering, maybe bantering, maybe saying, what the hell, get the hell out of my way, things of that nature. But again, this child is hypersensitive and hyper focused on anything that makes her uncomfortable goes from a 0 to a 10. So she calls the police. The police come, don't make any arrests. Nothing happens. There's no injury. There's nothing. My client then essentially just tries to work with the child here. Child's hyper focused now that everybody doesn't like her. And that's not the case. This is a child that is very, very sensitive, that needs a lot of extra care and probably needs agreement, guardian ad litem here, to help these parties deal with this hypersensitive child, to not feed into it, but at the same time to respect that it's there. But there is no domestic violence. This is not a man with a history of domestic violence. This is not, do they argue? Yes. Do they bicker? Most likely. But this is not a man that has any of those issues. With regards to the hair follicle, a hair follicle exam with an ETG goes back 90 days. It will pick up, because it's hair, it will pick up any sort of product you put in your hair that has any ethanol in it, which is pretty much 90% of cheap hair products. If you use really nice hair products, probably not. But the fact is, his was 0.23, 0.20 is a cutoff, which means he had just a tiny smidge that would show up on a hair follicle exam. That could have been from anything. It could have been from a beer that he had, absolutely, 3 months ago. But what is really interesting is that alcoholics, unlike other drug addicts and other addicts, can't stop use. And that is, they have the highest recidivism rate of pretty much any substance abuse. It can't stop and stop for periods of time and then suddenly start again. That's binge drinking. It's a whole other type of addiction. But Dad's UAs, which look back 72 hours, are both clean. We have 2 UAs taken like 2 weeks apart. They're both clean. That shows almost a 2-week window of not having any alcohol. If Dad is actually an alcoholic, that is one of the most amazing things, that Dad can do that, because most alcoholics can't do that. They require medical detox with benzos usually. If they're not that bad, they require lots of outpatient care to even be able to get to 2 weeks without alcohol. If we look at the SUDS again, Dad's very clear. Changing the mental health facility, her doctor quit or essentially moved up in the practice. There's child wanted care. Dad made sure to get care. With regards to the demanding the records, that's in the medical records themselves, in the mental health records, it clearly states that Dad asked her, child went, doctor said, and this is all in those records, doctor said to child, are you sure you want to do this? This is what they're going to use them for. Child said, I'll think about it. 2 weeks later, child said, yeah, I want them to have that. This makes sense. The child wants them to have it. Everything child's done is attention seeking. The self-harm is attention seeking in its own way. The hypochondria, the calling the police, everything that child's done is to get focus on her. Everything, and that is included in this. It's that she wants the court, she wants everybody to know how she's suffering, she wants this attention, she wants the parties to focus on her. This is not a case where Dad should not have visitation. This is not a case for supervision. This is a case for all parties here, Mom and Dad. They've equally done things, getting with new partners, involving the child in it, that are wrong for a sensitive child. They should both be they should all be in counseling together. Whether or not they hate it, they need to suck it up. They should both take children in between because they're not doing it right. And they should be working with the counselor together as a united front. This is a case where these people need to get over themselves and start working together, but it's not a case for any sort of suspending of visitations or changing that. Regard to the kill yourself comment. My client is a normal man, a normal guy. The child was refusing to come out of a room. My client said, well, if you're going to stay, they were watching a movie, if you're going to stay in the room for the rest of your life, you might as well kill yourself. Not kind of a crass comment. Had he realized that this child was suffering as much as she is, he wouldn't have stated it. He thought it was funny. Child didn't take it like that. He'll never make the comment again or anything like that. He now knows how much it upset her. He's just a normal guy trying to understand a child that's very different from the rest of these people. But both of these parties have caused this. They fed into it, but Mom, with her secret relationship and her leaving the marriage for her son's friend, Dad for getting with a woman that he's going to marry when he didn't marry Mom. This is a lot for a little girl to handle. Finally, attorney fees, and I've talked way too long and I apologize. CIRs are very specific in that they do not allow any form of attorney fees. They don't allow it. And this case is not filed as a separate parenting plan. It's filed as a CIR with the parenting plan included, and that is acceptable under a CIR. So while it might be easier to do it the other way, it hasn't been filed in that way. Additionally, Mom doesn't have a need. Mom makes good money. Dad doesn't have the ability to pay, and he's paying for himself, and it's going to be most likely expensive. We'd ask for no attorney fees. I think we're here when the parties should have been trying to work on this. A guardian ad litem is probably not a bad idea, though. Not even for the investigation, just to get these people some resources. The child's not going to get any better unless they start working together. Thanks.
Thank you, Ms. Winkles. Ms. Gilmore.
I do apologize. I somehow missed this substance abuse evaluation. It does look like it was filed on the 3rd, which I believe is Friday. Did have the opportunity while counsel was making arguments, just briefly glance over, and I do have some current concerns. Father, frankly, doesn't report anything to the provider. I don't see anywhere where he disclosed his numerous DUIs as recent as 2020. He actually, on page 2, under dimension 5, reports that he has gone a year without using alcohol, which is directly contradicts his own statements in a declaration. That's what I see here a lot of contradictory statements to excuse or explain away bad behavior of father. And again, I think that he really at this point is willing to, again, throw this child under the bus and say that she's overly sensitive. But I don't think that the mental health records really suggest that she's not disclosing anything that's what she believes to be inappropriate. And I think that frankly, it is inappropriate. It is inappropriate to tell a 13-year-old child to kill herself. And I think that the crux of that is the father alleges that he's in support of the child's mental health. He spearheaded getting her to treatment, but then admits to making these type of statements. Again, all of this information just simply contradicts itself. And again, I would just like to highlight, he now admits to having a DUI, multiple DUIs, but I'm looking to page 3 of his declaration midway through. He suggests, in 1997, I was arrested for both minor possession as well as a DUI. I was 17, 18 years old when this event occurred. I'm now 46. I mean, these are all suggestions that he doesn't have an issue. He's willing to make excuses. And the child is frankly continuing to have ongoing issues because of the back and forth yo-yo of father prioritizing alcohol beyond his visitation and relationship with his child. So I do ask the court grant our motion.
All right, thank you. All right, I appreciate the parties' emphasis of your different points and the argument presented. Having made that finding of adequate cause, I just want to talk a little bit about the child. I found interesting one of the doctor's entries indicated that this, I think they described it as a complex presentation. And I think that's a fairly accurate portrayal. Like I said before earlier in the docket, humans are complex, especially when children are young, they're growing, they're developing, they are encountering a huge life change, that their parents are no longer together. There's involvement of the children in adult issues. There's new companions, new partners. Terribly difficult and hard for a child to navigate all of that when they themselves are trying to get their feet underneath them, and the carpet's kind of been pulled out from underneath them. So there's some real challenges there for the young lady that she's working through. Could it be attention seeking? Yeah, it could be. Could it be other things? Yeah, it could be a whole host of issues. And gratefully that there's medical professionals and others that are giving their best efforts to address those issues. I'll just touch briefly, the change of the mental health provider. It sounds like there's some rationale for doing that. And I think anytime that there's been a separation between parents, the actions of another are always met with skepticism and suspicion. What I think is important is that the child is continuing to receive care, so that's great. And I appreciate the parents doing that and making her a priority. The issue related to the alcohol and Mr. Bamer's consumption of the same. So I think the records are fairly clear that he's had 3 DUI convictions. 2 are much earlier in his life, and 1 occurred in 2019. And I think the conviction occurred in 2020. So what that suggests to me, and then I take this into, I looked at the evaluation, indicated that generally takes about 2 to 6 hours a week of drinking activity. That doesn't necessarily mean that you're taking one beer or one drink after another for 2 hours, but it's sitting in a social setting or otherwise consuming alcohol anywhere between 2 to 6 hours. I think that's interesting, and the overall sense I got from the evaluation, the evaluator indicated that there was, I think the phrasing was possibly downplaying issues. I think as a human being, it is very difficult to self-assess and have a very clear picture of what we are, what we're doing, how we present, and what we're doing in life. And our normal reaction to being confronted with something that's maybe not right in our life is to minimize, is to downplay. That's my sense. That's what's happening here, is that Mr. Bamer has been able to function well during his life and continue to drink alcohol. And sounds like he has no plans to quit drinking alcohol. There was some suggestion that naltrexone, which my understanding is it's a drug that you take, and if you consume with alcohol, it makes you pretty darn sick, and it's definitely an aversive medication. Whether Mr. Bamer is willing to do that, that's really not my call to make at this point. If he's interested in showing that alcohol takes a backseat to his child, that might be a consideration, but I'm not making any rulings related to that. So I think that combined with this separation between the parties, Mr. Bamer was pretty forthright and indicated, yeah, I started drinking maybe more heavily than I had in the past. And I get that. And what that suggests to me is that there's some coping skills that maybe have not been fully developed, that the alcohol has served as a crutch for a long time. And when the going gets tough, rather than using different coping skills, alcohol is turned to as a coping skill, which generally is not a good long-term effective coping tool. It may be feel good in the moment, but overall it doesn't necessarily lead to addressing underlying issues that every single human has, and that we all do our best to try to cover up through different ways of coping. So I think I think that SUD evaluation, a new one, needs to occur with collateral input from the Ms. Kelly and also the guardian ad litem that I will be appointing. So I think that's important to look at that more closely. As far as the guardian ad litem, I will appoint a guardian ad litem. It'll be private pay. And I'll ask if we can just address that now by having the clerk share the 3 next individuals on the list, and then each party can strike if they'd like.
Ann Height, Twyla Corey, Keith Lawrence.
Okay, so in order, we have Ann Height, Twyla Corey, and Keith Lawrence. Moving party is Ms. Gilmore.
And we already did. I'm fine with Ann. We already discussed that. Ms. Winkles, are you fine with her?
Yeah, I was going to strike Keith Lawrence. So yeah, Ann Height's fine.
Okay, Ann Height is hereby appointed as guardian ad litem. Her job obviously will be includes addressing issues of alcohol consumption and impact on parenting, father's relationship with his partner, mother's relationship with her partner, the daughter's mental health and well-being, and how best to support her. I think it goes without saying that the counseling for the daughter will continue, and that both parents should and are required to complete developmentally appropriate class for children. For parents, for children who are undergoing a divorce or separation. I think that would be really important. Both parties focused on the comment made by the father related to his daughter not coming out of the room. And I thought it was interesting that Mr. Bamer included in his declaration, he said, I was making a joke to my child like I'd made 1,000 times in the past, which when I pause for a second actually hurts my heart quite a bit. Children are exceptionally sensitive to anything that their parents say. And I don't know if Mr. Bamer needs to hear this or not. Maybe he doesn't. But when a parent tells a child to go kill yourself, that is a clear, direct statement to your child that you do not matter as a human being. And if you cease to exist in this life, no big deal. It's terribly damaging. And if it's occurred on a repeated basis, that has to stop. That has to absolutely stop. And hopefully it has, and hopefully it'll never repeat itself. And hopefully that those comments were made during a time when there was maybe intoxication or what have you, or maybe the inhibitions were down. But that has to stop. Words are absolutely powerful. Children take them to heart, and they permeate, and they stay at the cellular level, and they manifest themselves in decades later. That has to stop.
I understand.
And my client is enrolled in parenting classes, a couple of them already. So we're trying to deal with those things.
Okay. The next kind of the elephant in the room related to the parenting plan and the parenting time, residential time. This is my sense. A lot has changed for this young lady. A tremendous amount of upheaval and change has occurred and is occurring all about her. If I were to change the parenting arrangement, I'm concerned that would cause further disruption and may not be in our best interest. So what I'm going to do at this time is keep the parenting plan, the status quo that the parents had been involved in, which is the 50-50. The guardian ad litem will be appointed. Guardian ad litem will issue a report, and we'll take a fresh look at things based on that report to see if there does need to be some type of change. But at this point, I'm going to leave that as is. The parenting decision-making will continue to remain joint. The alcohol testing provision remains in place. I'm sensitive to the hair follicle test because it does go back. My sense is that what the court's more looking at is if there's drinking during residential time. So in other words, when the father has the child during his residential time, when it's his residential time, there can be zero consumption of alcohol. And what becomes a little bit tricky with this is that at the end of his time, let's say it comes to the end of the week, it's Friday, and Friday morning he drinks a beer, and then the mother requests, maybe it's at 4 o'clock, and then it's after the exchange has taken place. There's an alcohol test. So what that probably does is limits Mr. Bamer's alcohol consumption to probably the next week, Tuesday and Wednesday. And that's probably about the only time he's going to be able to drink. So it's going to significantly curtail his any consumption. So the mother can request an alcohol test that has to be taken within 4 hours at any time during his residential time, and the day before the visitation, and up to 24 hours after a visitation. That request can be made. And so that puts really tight constraints on Mr. Bamer. I want him to understand that this is the court is taking this seriously. It may not be an issue, but I'm erring on the side of caution. But that provision will be in place. Related to the parties didn't address child support at this point. So I think I'm going to hold off on that. Because it is a 50-50 at this point. That may certainly change in the future if there's a showing that there's a need for one parent or the other. As far as the attorney fees, I'm going to hold off on that. I'm going to reserve on that issue at this point in time. We're here fairly early. It can be raised at a later time. I believe that addressed the issues that the parties presented to the court. I may have missed something, or the parties may need additional clarification. So I'm open to hearing from each of you.
Actually, before the court on a presentation of the order as well. I know counsel presented objections. I do not have them in front of me right this second. I guess I would just defer to the court on whatever changes you made. Did you receive a bench copy of that? Is that before you?
No, I don't have that.
Maybe we can address at the next presentation all orders. Is that fine with you all?
Yeah, that works for me. We can address, because
Okay.
I didn't think it changes anything. It's just to clear up the record.
Yeah, okay. And then my last question is percentages on for the GAL with a private pay. There is a disparity of incomes, and I both of us presented worksheets.
Yeah, let's address the presentation date first, and then we'll talk about the percentages. Presentation date, would the parties be available on the 21st of November?
Yes.
Okay.
I have a trial, but I always have a trial. So they go or they don't go. So I'm just booking things. So.
Okay. Well, let's set up for the 21st of November at 9 a.m. for presentation of all orders. Regarding the percentages, this is what I found. As far as the mother, I found her net at 38, her gross at 38.61, her net at 32.34. For the father, I found his gross to be 66.60. And I wasn't exactly sure on the net with the deductions. I kind of gave it a thumbnail view and set it at 5,800. So we'll use the 5,800 as the net for father, 3234 for the mother. And this is for purposes only of guardian ad litem's division of fees.
Okay.
Additional items, either Ms. Gilmore or Ms. Winkles.
Your Honor, you said parenting classes were important. We're ordering those though for both parties, correct?
Required, correct. And I was this close to requiring both parties to undergo counseling, because my experience has been, and it may be off, is that when a child is suffering deeply or having a lot of difficulty, the parents in being in counseling also can certainly help a lot. And it sounds like Mr. Bamer is doing that, but so I'm not going to require that, but the class I am.
Okay, sounds good. I have no more questions.
Right. If there's nothing further, that'll conclude the case for today, and we'll see everybody on the 21st of November at 9 a.m. for presentation.
All right, thank you, Your Honor.
Thank you.